Hello and welcome to Project Justice. I am Metuh Moran. Last Thursday, Federal High Court in Abuja ruled against a request to subpoena former National Security Advisor Sambo Dasuki to testify as a witness in the trial of the former spokesperson of the People's Democratic Party, Olisa Metuh. The ruling of the court is quite significant as it is the first of such since charges were filed against several persons in connection with the so-called Dasuki Gate. In fact, it is the first of such requests by a defendant in a charge related to the issue. Dasuki himself is facing charges for allegedly mismanaging monies meant for the procurement of arms to prosecute the war against insurgency. Olisa Metuh, on the other hand, is accused of receiving part of that money, about 400 million naira, for political campaigns and allegedly diverting some to his personal use. So indeed, it is a trial that has generated a whole lot of public interest, and it is based on the public's right to know and understand the technical intricacies and legal details of the trial that we shall be discussing the issue on this episode. This is all the more important because in criminal trials, justice must not only be done, but seen to be done to the victims, the defendant, and the state. Our guest today is a legal practitioner, Emmanuel Anene. But here's an update on some top stories in the judiciary and human rights sector for the week.
Nigeria's Chief Justice Designate, Justice Walter Onoge, has been confirmed by the Senate for appointment in substantive capacity. This followed a rigorous screening exercise at Wednesday plenary in the Senate chamber. Responding to questions on the threat to the judiciary's independence, Justice Onoge asserted that no one can or will be allowed to pocket the judiciary, warning that any such attempt will be tantamount to killing Nigeria and destroying its democracy. On corruption on some members of the bench, Justice Onoge said that no litigant needs to see a judge in order to get justice, assuring that his reforms will help restore public confidence and credibility to the judiciary. Abuja Federal High Court has adjourned ruling to 10th of March on applications seeking to amend an originating summon, asking for the removal of the Sokoto State Governor, Aminu Tambuwal, from office, on the account that the primary election of the All Progressive Congress, APC, that produced him for the 2015 governorship election was not validly conducted. Senator Umaru Dahiru, an APC governorship aspirant, filed the application before the election on April 11, 2015. In the amendment, Senator Dahiru is now asking the Federal High Court to remove Governor Tambuwal from office and declare him as the winner of the December 2014 APC primary election.
Thank you very much for agreeing to speak with us, Anene.
Thank you for having me.
When the court talks about a necessary witness, or when a party to a case says a particular witness is a necessary witness, what does that mean?
It is not for anybody to determine who is a necessary witness or not. It is when the witness, adduce evidence before the court. That is only when court will be in a better position to place weight to the evidence to be, adduced by the person before the court, not when the person has not testified. If you say somebody you have not listened to, that the witness is going to present before the court is unwarranted, is uncalled for, and it will amount to nothing, that you have shut the person out.
So is a court trying to preempt what your case should be now by denying the opportunity to bring this witness before it?
It is not for court to determine how you conduct your case. It's not also for court to determine who your witness should be. As long as you have list of witnesses and subpoena issued to the court is, the court's hand is tied. It must listen to your witness. Otherwise, the issue of fair hearing will always come up. And once a fair hearing issue is raised at any time, the trial will be quashed.
The question some have raised is, why did he not submit the name of Sambo Dasuki as one of the list of, among the list of witnesses to be called by the defense?
No, if you look at the list of witnesses the defense submitted, he submitted 3 witnesses and also submitted about 3 subpoena. There is no rule of law that provided that you must mention all your witnesses. And there is no law that said the witness so mentioned must be cast on stone. That once you list 6 witnesses, you are not going to, call any other witness. The only thing is that if you want to call additional witnesses, apart from the person you submitted before, you just notify the court on time. And that must be done within the time frame allowed by the law for the defense to take his case. As long as this is done within the time, there is nothing anybody can do about it. The court must hear Dasuki in this case. Otherwise, it will be breach to fundamental human right of fair hearing.
What are the circumstances surrounding Dasuki that informed the defense to require the court to issue a subpoena for him to attend court?
You see, one thing is this. Dasuki is the former NSA, National Security Advisor. Now, and it is his office, the office that is pretend, was the office alleged to have dished out certain money that they call it, they say it is arms money. So, Dasuki is a star witness in this case. And mind you, let me say this thing to correct certain impression. If you say somebody collected somebody collected money or property from a particular person, that is receiving stolen property, knowing it to be stolen, the first thing you should do is to try and convince that person to show the world or to establish that, first of all, the property or the money is dishing out was a stolen property. That has not been done. So now, if you are now saying that the person who gave out the money that his evidence is not necessary, then, and you are trying somebody that received the money, it doesn't add up. It will not add up. There is a missing link. Dasuki his testimony must be taken. He will be able to tell the court what he knows about the case or what he knows about the money. If the money was given illegally, he will say it. If the money was given in course of his carrying out his responsibility as a former NSA, he should also state it. That is only when we should be in a better position, or the court will be in a better position to ascertain whether this money was received by the accused person or the defendant, knowing it to be a stolen money. The underlying word is knowing it. You can receive money from anybody. I can receive money from you. It doesn't behave for me to start asking you, where did you get this money? No, if you give me money, I receive the money. But if it's established that the money you gave me was a stolen money, and I knew it to be a stolen money, then I'll be culpable to have received a stolen property or property acquired illegally, knowing it to be acquired in such instance.
So from your point being that it is only Sambo Dasuki that would determine or tell the whole world whether or not the monies issued out was a proceed of illegal activity.
It's not only Dasuki in this case. There may be reason to call the former president, because if Dasuki is an aide to the former president, it's not only Dasuki. Dasuki must, but first of all, Dasuki must state what he knows about the money. As at the time he was giving out this money, what was operating in his mind? Was it an illegal money? Did he inform the recipient that this money was illegal? Then did he have an order from his boss to issue out this money? These are the things that will form the opinion of the court when taking this decision. But once these things are not done, if somebody says only Dasuki can come to the court and say, my Oga gave me the authority or the directive to issue out this money. Now, if you want to go further, you have to call his boss to ascertain from him whether such directive was given to him. So if all these things are in place, then it means that the defendant did not receive any stolen money, knowing it to be stolen.
If Dasuki indeed comes to the court to say that, will it open a Pandora's box of some sorts? Because you expect that he would also more or less indict the former president, and the former president will be asked to appear before the court. Is that what the court or the prosecution is trying to avoid?
No. Excuse me. You cannot restrict the defense from carrying out his case. It behoves from them to know how to conduct their case. And let me say this thing again. The court said that Dasuki is not a compellable witness. Who is a compellable witness and who is not a compellable witness, without giving further reasons. Now, competent and compellable witness is somebody that is not under any inhibition. Now, he's not being protected by Section 308 of the Constitution that gives them immunity against subpoena. Dasuki, for all intents and purposes, is a competent and compellable witness. That is number one. Number two, whether Dasuki is coming to open any canker of worms, so be it. The defense must be allowed to be given fair trial and fair opportunity to defend themselves, including if it amounts to calling the former president to say what he knows about it. Somebody's somebody's right to freedom is at stake. If you are saying he's coming here to open up a lot of canker worms, open up a lot of things, and his right to freedom of movement is being curtailed, on ground of this trial. He cannot even have his passport to go and treat himself. Is he going to continue to wait until a cankerworm is not going to be opened before he defends himself? That is not the principle of law. The principle of law is that once a person is accused or alleged to have committed any offense, he's being availed also manner of time and adequate. He said adequate time and opportunity. Adequate time and opportunity on the line to defend himself.
Is that section of the Constitution in conflict with the Administration of Criminal Justice Act?
No,
that gives the judge the discretion.
There is no discretion. If you look at it, the judge may. That may in say it's not discretionary because he did not state any condition to be fulfilled. Mind you, the judge said that
if it says may, it means he might decide to do or not to do.
In this instant, the word may shall be interpreted to be shall, because that may is not hint on any condition. It's only when he said these conditions must be met. He now give the judge discretion.
Is there at any time a may word can be interpreted?
Yes, in this manner, because
with a mandatory intent.
Yes, there are plethora of decisions to that effect. As long as the certain conditions were not listed to say if these conditions are met, like what the judge was saying, was trying to bring common sense to it. To say you would have first of all written to the authorities that are in custody of Dasuki, and if they fail, you now approach.
Did you do that?
No, it's not necessary.
Was it done in this?
The Constitution is an absolute provision, and the section that they relied to give this ruling did not state any condition. He said the judge may issue subpoena when a prosecution or defense requests for it. That is the paraphrasing of that section. He did not give any condition. He didn't say you must do X, Y, Z.
It could also be interpreted that if the ACJA, the Administration of Criminal Justice Act 2015, says the judge may grant a request for subpoena, some would also interpret it to mean that the judge may decide not to grant the request. No, when you read it
in line with the constitutional provision, that's section 36, sub 6, sub D, that's an absolute provision. And that is the parent law. Even if, assuming without considering that section gives the judge discretion to issue subpoena or not to issue subpoena. When you read it in line with section 36 of section 66D, that is an absolute provision, that provision of ACJA is inconsistent with the provision of the Constitution. And the provision of the Constitution must hold sway because it's a mandatory clause. Shall. So I don't know why people are mixing it. There's nothing. Everything is clear. It's not that I think something is playing up somewhere. Something is playing up. You see, in criminal trial, the essence of criminal trial is not to secure conviction by all means. It's to make sure that justice is done. Not only done, but must be seen to have been done. You must not get somebody convicted by all means. Otherwise, it's turned to persecution.
Is the defense getting that sense in this case, especially with the denial of this request to subpoena Dasuki this case?
Yes. If Dasuki is a key witness or a star witness and you are shutting him out, there's no way he will be convinced that at the end of the day, the verdict will not be simple, and that is guilty as charged. Because certain persons and individuals that are supposed to testify for him and are supposed to bring certain evidence that will make him run off the hook. If you refuse these people from testifying, you have muddled up everything. The defense is not complete. And if the defense is not complete, the verdict is simple. Guilty as charged.
Does the absence of Dasuki, or what does the absence of Dasuki, how much damage would it do or help would it do to the case of the prosecution?
Dasuki must testify in this case. As long as he's not under inhibition, he's not going to cause any delay. He's within the jurisdiction. They're not going to spend any money. They're in custody of Dasuki. Dasuki is not a fugitive. So bringing in Dasuki to testify, may or may not even help the defense in carrying out their case. But to satisfy the constitutional provision of giving him that adequate time and opportunity, of giving him that leverage to summon any witness to testify on his behalf.
Dasuki himself is facing trial.
Yes.
And we are hearing that even Dasuki cannot have access, or his lawyers cannot have access to Dasuki to prepare for his trial.
Anyway,
you requesting for Dasuki. Yeah, I know there are two different cases.
Dasuki's problem with
I'm just bringing this in.
Saying,
if Dasuki as a person,
yes,
who is standing as a defendant in a criminal matter in another case,
yeah,
can't even have access to his lawyers, that could still be interpreted in the context of, access to justice or fairness according to a defendant to prosecute.
The moment the Dasuki trials begins.
Yeah, would you not be being over optimistic to think that if the government can deny him access to his lawyers to prepare for his own trial, will that same government allow him to stand as a witness in Metuh's trial?
It's not about what government wants. It's about the constitutional provision. Unless we are saying we should throw the rule of law to the dustbin. If rule of law, that is the cardinal principle of democracy, must be practiced, Dasuki must be allowed to have access to his lawyer and defend himself. But that is not the subject matter here. The subject matter is somebody who is undergoing criminal trial is saying, I need Dasuki to come and testify in this case, being a star witness as far as this case is concerned. And somebody is shutting him out. So if this is done and the trial is concluded and verdict given in one way or the other, it will not stand.
All right, you're still watching Project Justice on AIT. We'll take a short break now. When we come back, we'll continue with our interview. Do stay with us. Emmanuel Anene is an Abuja-based legal practitioner. Is still our guest here on Project Justice. Emmanuel, what options are available now for the defense in a situation like this? And what precedents do you have to proceed from here where a necessary witness, according to you, is being shut out from testifying in a trial like this?
The defense, he has senior advocates that are representing him. They know what to do. But if I may give them unsolicited advice, they have the right to appeal, file notice of appeal, and the states one by one the grounds of that appeal, which is one, the application that the judge even ruled was not controverted by the defense. They did not object to it. And there is an affidavit evidence attached to it. And once an affidavit evidence is before the court and properly moved and not controverted or countered by the adverse party, it stands as a positive evidence.
That's an interesting point. That's an interesting point you raised, because
the court must act on. It is not
the prosecution did not object in this case.
Yes, the prosecution had necessary time and opportunity to controvert that affidavit, and they did not do it. Instead, they said they are not opposed to it. The consequence is that those affidavit evidence, the facts adduced in those affidavits are positive and direct, and the court must act on it. It is not for court, like in this instance, to create imaginary counter affidavit to say he has gone through it and noted. There's nothing like noted. It's before the record that they did not object to it. So the court must act on it. But in this instant, the court created an imaginary defense to say he is not satisfied that this application is ordinary. What makes the application ordinary? An application to subpoena a witness. These are the necessary facts that the prosecution would have countered by filing a counter affidavit. Now, that will now give the defense opportunity to file further and better affidavit and reply on points of law. But because the judge assumed the role, that descended into the arena of conflict, by assuming the role of the prosecution to say he has gone through this and didn't see anything, now the defense is also shut out in this instant, because there is no way they could have replied the judge. If that work was done by the prosecution, probably the defense would have had the opportunity to file further and better affidavit and reply them. But that did not happen. That's number one. Number two, he said somebody is not a compellable witness and that person is not enjoying immunity. It's also appealable. Now, number three, and most importantly, the witness you have not heard from, you said it's of no moment calling him. Meanwhile, that witness is a star witness. These are grounds upon which they can appeal. That is by filing, we call it interlocutory application. And if the time permits them, they can also file stay of proceedings. Because if Dasuki's evidence is not taken in this manner, I don't think any sound decision will emanate from that court at the end of the day. That's my humble opinion.
What would be your general appraisal of the conduct of the judge, especially in this particular case? Because we've had a series of seeming face-off between the defendant in this case and the trial judge in this matter.
Well, I'm a lawyer. Let me speak from the realm of the law. But as a Nigerian, there have been some face-off. The accused person said the judge was his classmate. He said it's not his classmate. A petition was written asking him to step aside. He said no. The atmosphere has been combative. But the essence of criminal trial, like I said before, is to see that justice is done. Once an accused person or a defendant say he has lost confidence in the judge, the judge has duty bound to step aside, because there is no ruling or judgment that will emanate from him that the other party will not challenge on ground of lack of confidence, because of the way and manner the trial is going on, as if to say there is a cold war between the defendant and the court. In some instances, like this one we are now discussing, application to summon a witness, that was not opposed. It's a harmless application, innocuous application. Just ask this person to come and testify in this matter. And the prosecution say, we are not objecting to it. Now, I wonder why the court is making, heavyweight out of it. Whether Dasuki is coming to exonerate him is a different thing. Whether Dasuki is coming to even indict him is also another thing. But the court must be seen to be impartial and independent. It will detach itself from the trial. It's between the accused person and the prosecution, and not between the accused person and the court.
Where does technicality fall into all of this and the need for substantial justice to be done, especially in a criminal trial of this nature?
The issue of technicality is even the prosecution or the judge that is even hinging on technicalities that he did not write. The substantive justice there is that Dasuki should come and testify. Now, it's even the court that is saying there was no letter saying requesting that he should come and testify. For me, that is technicality. Dasuki should come and tell us what he knows about this matter. That is the justice of this case. If Dasuki comes and said it was lawful or it was illegal, that will help the court to form a better opinion at the end of the day. So, technicality, I don't see any technicality being played out by the defense. They want substantial justice, and substantial justice must be established, or will be seen to be established, if all the witnesses that the prosecution or that the defense wanted to testify before on its behalf are allowed to testify. Then at the end of the day, anybody who is giving any judgment would have been in a better position to so hold or to so decide. So the technicality there cannot be that I am requesting the attendance of somebody who is not under immunity, who is not under any disprivilege to come and testify on my behalf, and somebody is shutting the person out. Dasuki must not be seen to be under duress to testify, because they may also want to use this thing as a card. If you testify this way, we'll let you off the hook. By the way, his trial is not going on.
And since the judge said that you would have fulfilled a condition first, which is right to get him to appear before the court.
Where is that condition emanating from? From the Constitution? The Constitution did not provide for any condition.
But what would he have stopped the defense to do that?
Where is that condition emanating from? From the Constitution did not provide for any condition.
But did the defense ever, on its own volition, make an approach to the witness in question to appear before the court?
It is not for defense to make approach. The procedure is that if you want to subpoena a person to testify before the court, you apply to the court. I need this person to testify on my behalf. And if the court will issue subpoena, requesting that person to come and testify. That's simple. There's no condition. The condition has been fulfilled by the defense, and that is informing the court in writing or by application that they want Mr. Colonel Sambo Dasuki to testify in this case. And that has been done. So the issue of writing DSSS or writing EFCC or writing this thing is such an imaginary condition created by the court itself. It never existed, both in the Constitution and Administration of Criminal Justice Act.
If Dasuki was not in detention, would you still have requested a subpoena through the court to have him testify?
Whether Dasuki is in detention or not, it doesn't matter. If Dasuki being in detention makes it easier for the states to bring in Dasuki. Or you go and tell them what you know about this matter. After all of us are interested in getting some of these things sorted out so that we know who stole what and who did not steal anything. You understand? So if Dasuki is in detention, that makes it easier for them. If Dasuki is a fugitive, the court would have been in a better position to say getting the Dasuki will amount to delay in this trial. But Dasuki is being heard within the jurisdiction of this court, and it's being heard by the state.
Going by the Administration of Criminal Justice Act, even if the defense intend to appeal on this case, they still have to go ahead with the trial before,
part of this
before the trial
Criminal
judge.
Justice Act is all that people have not challenged it.
But have you as a lawyer done that? That's your responsibility as a lawyer to challenge it.
The issue of if you file it, the issue of local standing will come up. They say you don't have local standing. It is the defense that will say this issue of trying continue when you are challenging fundamental basis of that trial. For me, it doesn't do justice to both parties, and justice must be seen to be done for the three parties: the state, the accused person, and the prosecution. So you cannot only do justice for the state and think to have done justice. If somebody is saying, like in this stand, you don't have jurisdiction to try this matter, he said, no, and jurisdiction is key. If you don't have jurisdiction to try any matter, at the end of the day, it is a nullity. So this Administration of Criminal Justice Act that people are parading up and down is inferior to the provisions of the Constitution. And Constitution allows you adequate time and opportunity to defend yourself. And that includes appealing anything you want to appeal by way of interlocutory application.
Emmanuel, thank you so much for your time.
Thank you for having me once again.
Yeah. Well, that's Project Justice. Remember, you can reach us via Twitter. Our handle is @ProJusticeLive. Also watch us on YouTube by clicking on Project Justice. Like us too on Facebook. From the entire production crew, I am Utubal Moran. See you next week.